Good evening and welcome to this event hosted by the South Australian chapter of the Australian Association of Constitutional Law, the AACL. We're delighted to be able to host this event not only in person but also via the Microsoft Teams platform to people around the country. If anyone can't hear online, can you raise that in the chat? I'm not sure that we know how to fix it if you can't, but we'll have a try. My name is Stephen McDonald. I'm the South Australian Chapter Convener and also the National Vice President of the AACL. I'd like to begin by acknowledging that the land we here in Adelaide are meeting on is part of the traditional lands of the Kaurna people, who are the traditional custodians of the Adelaide Plains, and we respect their relationship with this country. We're fortunate tonight to have Rachael Gray KC, who's offered to speak to us on the topic of the individual, judicial method and three judgments of Justice Edelman. Dr. Gray first gave a presentation on this topic to a conference of the South Australian Bar Association earlier this year, and we're very pleased that she's agreed to share her thoughts with a wider audience. So the intended format is that I'll introduce Dr. Gray, she'll give her presentation, and then we expect there'll be some time for a few questions at the end. We have the capacity to receive questions through the Microsoft Teams chat. So while I won't guarantee that your question will be answered, that is possible and we will see them. So include any questions in the chat. Can I also please ask that if you're on Teams that you mute yourself and also turn off your camera. Now there's a written version of the paper that Dr. Gray will deliver and copies have been distributed via email to those who registered. We've also got hard copies here in the room. I should let everyone know that the event is being recorded and the intention is that the recording will be made available online, in particular on the AACL website. Speaking of which, I should mention that we have a brand new revamped website, www.aacl.asn.au. So I encourage everyone to check it out. You can also sign up for membership of the AACL there if you're not currently a member. But let me now turn to introduce our speaker. Dr. Rachael Gray is a practicing barrister here in South Australia and is a founding member and head of chambers at Victoria Square Chambers. She has a very broad practice covering the practice areas of civil, commercial, industrial, workers' compensation and estate litigation, as well as all areas of public law, including constitutional, administrative appeals, judicial reviews and inquiries. She appears in both trials and appeals. She's even appeared as senior counsel assisting the parliamentary inquiry. Dr. Gray joined the independent bar in 2009 and took silk in 2018. Before coming to the bar, she was counsel assisting the state coroner and deputy state coroner. Dr. Gray was awarded her PhD in constitutional law in 2007, having written a thesis that focused on judicial method and in particular a comparison between the Dixon, Mason and Gleeson courts, which was later published as a book in 2008. So she's been thinking about these kinds of issues deeply and over a considerable period of time. So please welcome Dr. Rachael Gray KC.
Thank you, Stephen. Thank you for that very generous introduction. I would also like to acknowledge that we meet on the traditional lands of the Kaurna people and that we meet here over in Victoria Square or Rundunya, which is a traditional meeting place of the custodians of the land. Of course, when I began practice in the early 90s, there were still groups of Aboriginal people meeting in the square, but when it was beautified in the 2000s, that doesn't occur as much anymore. I just make that observation, but I acknowledge that it is the traditional place of the Kaurna people. This is a slightly updated version of a paper that I presented to the Bar Association. So thank you, Steve, for inviting me to present it here tonight. It's quite special to me to be speaking to the AACL in the Selway room. It was Brad who encouraged me to join the AACL. I think it was, if you want to go to this conference in Sydney, you need to be a member. When the association was in its very early days and we were looking for members, and the General was here noting that in those days, Crown solicitors, solicitors within the Crown were funded to go to conferences in the state. So it's special to be speaking here today. There are three decisions that I'm going to speak about. firstly the Deputy Commissioner of Taxation and she, then ABCC and Pattinson, and finally Vanderstock. And then I want to make some observations about judicial method. It's quite a bit to get through, so I'll turn and go straight into the first decision. The first decision in Deputy Commissioner of Taxation and she concerned, and a key distinction in this case was between the majority judges, which was comprised of the joint judgments of Chief Justice Keeble, Gleeson, and a separate judgment of Justice Gordon, and Justice Edelman was the sole dissenter. And the key distinction between the minority judges and the dissenting judgment of Justice Edelman concerned the statutory interpretation of section 128(6) of the Evidence Act. The scheme set up by section 128(8)(a) concerned circumstances where a disclosure order is made against a person, requiring that person to disclose information. In Mr. Shee's case, a disclosure order had been made, which was auxiliary to a freezing order. The freezing order was part of civil proceedings brought by the Deputy Commissioner against Mr. Shee for recovery of tax, and the amount was a staggering sum 42 million. Under section 128, where a disclosure order has been made, the person may take objection to compliance with the disclosure order. And when someone does that, they file two affidavits, a privileged affidavit and an open affidavit. The privilege affidavit, which is prepared pursuant to section 128(a)(2)(d), contains the information which was required to be disclosed, to which objection is taken, and this is delivered, sorry, that's the privilege one, is delivered to the court in a sealed envelope. The open affidavit, which is prepared under 128(a)(2)(e), is filed and served, and that sets out the basis of the objection so that both parties know the basis of the objection. What then happens is that if the court is satisfied of three things, the court may order the whole or any part of the privilege affidavit is to be filed and served. So the three things the court has to be satisfied is, firstly, that any information disclosed in the privilege affidavit may tend to prove that the relevant person had committed an offence against or arising under or liable to civil penalty under Australian law. The second criteria is that the information does not, and the words are, tend to prove that the relevant person has committed an offence against or arising under or is liable to civil penalty under a law of a foreign country. So that it has to be that it doesn't tend to show that they committed this foreign offence, and that's one of the key things within dispute in the case. And thirdly, that the interest of justice requires the information to be disclosed. If the disclosure is ordered in the affidavit, the court must issue a certificate which prevents disclosure of the material in the Australian court in a manner that would be used against the person. The idea behind this, obviously, is that because Australian courts can't control information about foreign offences and can't limit the disclosure of that, it's important that there is that criteria that the information does not tend to prove that the relevant person has committed an offence against a foreign. The High Court, by a majority as indicated above, allowed the Commissioner's appeal, and the majority held that Mr. Shee did not produce evidence in the privileged affidavit that may tend to incriminate him in respect of a law of a foreign country. And therefore, the court had power to make an order under 128(a)(6)(b) that the affidavit be filed and served. The plurality held that Mr. Shee did not include any tendency information in his privileged affidavit to prove that he had committed an offence against or arising under or was liable to a civil penalty under any Chinese law. The distinction in many respects in the judgment depended upon the question of the onus and the extent of the evidence required to be adduced for the court to be satisfied that the evidence did not tend to prove the foreign offence. Justice Edelman, in dissent, analysed in a much greater detail what the affidavit material provided for. His Honour addressed the question upon whom the status placed the onus and why the privileged affidavit should not be required to be served. Justice Edelman in dissent held it was for the Commissioner to negate the position that had been established by Mr. Shee. Justice Edelman commenced his judgment by examining the extent of the onus to establish a privilege against self-incrimination. And what His Honour looked at was in particular the common law position. And His Honour said it has long been the case that a person claiming the privilege against self-incrimination is not required to spell out to the court the precise nature of the offence that the person might have committed and all of the facts upon which the offence depends. To so require could substantially undermine the privilege. Hence, in relation to the privilege, to declare to an answer to a question a great latitude was allowed to a witness in judging for himself the effect of any particular question. So, Justice Mr. Shee's submission had been that the section placed the onus on the Deputy Commissioner to negate his prima facie entitlement to the privilege, and that the Deputy Commissioner hadn't done that. Justice Edelman was the only judge who largely accepted that submission, and His Honour found that the open material that Mr. Shee had filed demonstrated that his objection concerning foreign law was based on reasonable grounds, and that basis set out in the open affidavit was confirmed in the material in the closed affidavit. His Honour looked at the Australian Law Reform Commission's observation about the reasons behind the establishment of this section and took quite a theorised approach in doing that. I've set out in the written paper the Australian Law Reform Commission's observations about that. His Honour, as I indicated, also looked at the common law provision. The objection to the foreign law that had been taken was based on offences including taxation offences, money laundering offences, secret commission offences and migration offences. The open affidavit received revealed that very substantial amounts of money had been transferred to China by various entities with the date range of the suspected offences, that there were circumstances surrounding certain payments which may tend to support the inference that Mr. Shee was the controller of those entities, that the payments made within the periods of the suspected offence to a recipient who was incarcerated in China with his assets having been seized by the Chinese government, and that those matters may tend to incriminate Mr. Shee in the offence of dealing with the proceeds of crime. So that was all material in the open affidavit. His Honour concluded that that was enough, and in my view, there was a very human aspect to the decision in that His Honour looked not only at the practical implications of the interpretation of the legislation upon the individual, but also at the question of what more could the individual in this case have done in claiming the privilege without having to actually reveal what offences they may actually have committed. And I think the statutory language of tending to prove the common law position, I think all supported that approach. But interestingly, all of the other judges took a completely different approach to it. So I thought that was an interesting decision because I thought they were so diametrically opposed in the way that they approached not just the decision making but also the reasoning process. And that, of course, caused me to look at more judgments. And the next judgment I'm going to look at is the decision in Pattinson. Now, I should say that overall, I think Pattinson is a terrible decision across the board. Justice Edelman took a different approach to the other judges in this case, but it wasn't a dissenting judgment. In Pattinson, the controversies in questions concerned a building site in Victoria, and that site was occupied by Multiplex Constructions, a principal contractor. Mr. Pattinson was an employee of Multiplex, and in addition, he was an officer of the CFMEU and a union delegate on the site. What had happened is the head contractor had engaged a subcontractor to install some solar panels on the site. Two subcontractors arrived. to be inducted to the site by Mr Pattinson, and he made an inquiry of them as to whether they were union members and whether they had a ticket. The inquiry was referred to in the judgment, as what's said to be a bit of a policy. I've got some slides up there about that. That the CFMEU had a long-standing no ticket, no start policy, pursuant to which all workers were required to hold union membership in order to work on the construction site where the CFMEU had a presence. Now, the implementation of that policy was something that, at least since the Workplace Relations Act 1996, has been unlawful. And Mr Pattinson had represented to the two workers that in order to perform work at the site, they had to be union members. These facts were admitted by Mr Pattinson in the federal court, and he accepted that he had twice contravened the relevant section, in that he had knowingly or recklessly made a false and misleading representation about the obligation of the two employees. Liability on behalf of the CFMEU was also admitted on the basis that Mr Pattinson was acting in capacity as a delegate for the union. The primary judge, Justice Snowden, imposed civil penalties, $6,000 in respect of Mr Pattinson, $3,000 for each contravention, and $63,000 in respect of the union, $31,500 for each contravention. At the relevant times, the statutory maximum for the CFMEU was $63,000 for each contravention. The primary judge, however, held that because the contraventions occurred as a single episode, each penalty was reduced by half. On appeal to the full court of the Federal Court of Australia, it was a bench of 5, Chief Justice Alsop, Justices Bazanko, White, Whitney and Bromwich, held that the history of the CFMEU's prior contraventions and the deterrent purpose did not warrant such a large penalty being imposed, because the penalty imposed was disproportionate to the nature, gravity and seriousness of the offending. The effect of this offending was that those two workers didn't work for one day. So it's a very large monetary penalty, having regard, you look at the gravity of the conduct. There's no wider stoppage of work, it's two workers in one day. The full court set aside the penalties imposed and imposed a penalty of $40,000 in respect of the union and $4,500 in respect of Mr Pattinson. The Commissioner appealed and contended the full court had erred. Firstly, regarding the discretion as being confined by the concept of proportionality. So in these civil penalty proceedings, the full court had applied the concept of proportionality, that you had to look at the gravity of the offending. And secondly, the Commissioner appealed on the basis that the statutory maximum was seen as a yardstick, in the sense that the maximum would only be imposed in the case of the worst type of contravening conduct. The majority of the High Court, which consisted of Chief Justice Keeple, Gageler, Keane, Gordon, Stewart, Gleeson, accepted both of those contentions and held that the purpose of a civil penalty is primarily, if not solely, the promotion of the public interest in compliance with the provision of acts by the deterrence of further contraventions of the Act. The majority found error in the full court's reference to the concept drawn from criminal law that a penalty must be proportionate to the seriousness of the conduct. And error was also found in this idea that you would only impose the maximum penalty for the most serious offending. The majority held that the purpose of civil penalties is primarily, if not solely, deterrence, both specific and general, of future contraventions. The majority held that the maximum available penalty is not reserved for only the most serious example of offending, and that an appropriate penalty was one that struck a reasonable balance between oppressive severity and the need for deterrence in respect of a particular case. The Honours held that the penalty appropriate to protect the public interest by deterring future contraventions could be moderated by a range of factors, but that such things as the nature and extent of the contravening conduct loss and damage cause and all of those things, but none of those things replace this concept of the primacy of deterrence. In contrast, Justice Edelman, so this was, the majority judgment was really the Deterrence 101, and in contrast, Justice Edelman took a very different approach. His Honour's judgment is what I think can only be described as a scathing attack on the concept of deterrence. His Honour's judgment commences as follows, and I quote, "It is sometimes just to hang an innocent person. That is where the logic of general deterrence leads. The logic of specific deterrence can also lead to gross injustice. It can create a legal position where, as Professor Zedner has observed, the utterly repentant offender, unlikely to repeat their crime, would not need to be punished, however serious the offence for which they stand convicted, whereas the unrepentant offender, who appears unlikely to change, might attract a penalty greatly disproportionate to the present offence." His Honour approved of the majority approach of the full court, holding that the full courts had engaged in a valiant attempt to reconcile the difficulty requirement, the principal focus of the court should be on deterrence, because that had fallen from other cases, and ordering a penalty in which a contravener in justice deserves for their past conduct. So this is this concept of just deserts, which you often hear in criminal law, in a civil penalty context, and in particular looking at this idea of proportionality between the nature of offending and the penalty that's imposed. Justice Edelman did not see the Act as mandating the emphasis that the majority placed upon deterrence, and was, I'd say, somewhat critical of the majority approach. But what His Honour held is it's hard to imagine that Parliament intended, by reference to appropriate, to set the foundations of punishment by civil penalties in utilitarian notions of deterrence. His Honour referred to the notion that monetary penalties acted to generally or specifically deter as being questionable. His Honour noted it's also an unfortunate truth that many potential contraveners, their officers or advisors, do not spend many hours each week carefully reading the wisdom collected on OSLI, JADE and other databases containing legal decisions on penalty. At best, general deterrence can only need be used to identify a range of penalties in which, in pure utilitarian theory, the lower end of the range, fewer potential contraventions will be deterred, and at the higher end of the range, more potential contraventions will be deterred. I'm not sure about that one. I think some of the legal officers said to me, you are very familiar with everything that's on OSLI. The actual union officials and contraveners may have lesser informants too. But I mean, there is a general logic in this idea that really by imposing these harsher and harsher penalties, are you really deterring conduct? And is the imposition of harsher and harsher penalties without regard to the individual circumstances of the offender and all of these other factors going to bring about a change in behaviour? I mean, that's really, I think at the core of this. And it's interesting though, because when you look at the language that Justice Edelman's using when looking at reference to the opposing view, he's using language such as, it's hard to imagine Parliament could have attended that. And I think it's a pretty strong language to be using about the approach that the majority of the judges at the High Court are taking, because it almost gets close to that admin law concept of no reasonable decision maker could possibly interpret this legislation in this way. It's like, well, that's the majority of the High Court. So, I mean, I found that interesting. Justice Edelman did accept the relevance of the principles drawn from criminal laws having application to civil penalties, and he adopted what I would say was a theorised approach to judicial reasoning, in that he looked at in abstract realm where the premises of utilitarianism hold true. It is theoretically possible for a precise point to be identified below which other potential contraveners will not be deterred but at which specific deterrence will be achieved. But he pointed out we don't live in that realm. And he referred to the attempt of courts to try and do that as a fool's errand. So again, quite strong language there. His Honour explained the difference between, on the one hand, assessing past contraventions as part of the seriousness of the conduct, and on the other, using past conduct as a preferable to need specific or general deterrence. I think on whatever approach was adopted, His Honour was clearly not sympathetic to the position of the CFMEU. His Honour commented that on either approach, a very substantial penalty would have been adopted. And in fact, there's elements of His Honour's judgment where I think he's almost suggesting, well, the union was actually lucky that Justice Edelman applied this, course of conduct and didn't hit them for even a higher penalty. So for those that are sympathetic towards the position of unions, there's no comfort to be gained in the way that the principles might be of assistance, but no comfort to be gained in what the actual outcome was. I think, however, what Justice Edelman did in Pattinson, which wasn't found in the other judges, is he really looked quite differently at the position of Mr. Pattinson and took quite an individual approach. I mean, this is a union delegate of some 20 years as a site delegate who'd never previously contravened the Fair Work Act or its predecessors. Now, for those that practice in this area of law, that's not a common thing, particularly in times when the ABCC had the powers that they did have under the previous legislation. And he was quite sympathetic towards the position of the individual. But ultimately, even though he was very critical of this use of deterrence, he ultimately held that the full court or the federal court should have applied deterrence just because of the document precedent. So I think there's a real tension in that judgment. So even though he's had this scathing attack on the use of deterrence and sentencing, he's actually said that the full court should have applied that because of precedents. So interesting. The next decision that I'm going to talk about is Vanderstock, and I will, noting the time, and this is a very lengthy decision. We have a copy if anyone here wants to look at the actual decision. I think anyone who sees this decision as being a movement by the majority to support environmentalism, I think might be misguided because the number of trees that are printed like that will destroy. It's a really long judgment. And so any environmental benefit of the decision, I think, is substantially reduced by the number of pages it is. But for those of you that are interested in knowing, and looking at the actual outcome of this, the test, although Mike Wade, who's here today, might say it's not a test, but the majority position is set out in 2 paragraphs, which sets out the test, which I've extracted in the paper. So if you want to go and just read the actual part of it, I think you only have to read paragraphs 146 through to 148, but there's also a whole ream of paper that you can read about the reasoning for it. The majority approach is found in the joint judgment of Chief Justice Keefull, Justices Gleeson, Gagler, and in a separate concurring judgment written by Justice Jago. The majority in finding the law to be invalid, and this is a law which was Victorian legislation, I might say something about that, that imposed a fee on the use of electric or hydrogen zero low emission vehicles, and was challenged as being an excise. The law was held to be invalid as being contrary to the exclusive power of the Commonwealth in section 90, and as in reaching that finding, they overruled an earlier decision of the High Court in Dixon Arcade, which I think had been with law for 71 years, wasn't it? Oh. Or was that 60? Yeah. 60 years. In which it was, sorry.
it was articulated, I think, 70 years ago, and then it was affirmed by the majority of the High Court 60 years ago.
For a very long time. It was held to be a tax on the consumption of goods did not constitute a duty of excise, so they overruled that position. A tax was held to be a tax on goods and thus an excise in two circumstances. Firstly, if it bears a close relation to the production or manufacture, sale, distribution or consumption of goods. And secondly, if it is of such a nature as to affect the goods as substance of manufacture or production or as articles of commerce. So ultimately, this is an expansion of power. The challenged law was considered in Vanderstock to be a tax as it was of such a nature that it sufficiently affected goods as articles of commerce and the tendency of the tax to depress demand for those goods. The effect of the majority decision was to find that the purpose of Section 90 was to give Commonwealth Parliament exclusive control of taxation of goods so as to ensure that the execution of whatever policy the Commonwealth Parliament might choose to implement through the enactment of uniform laws of trade, commerce or taxation would not be hampered or defeated by the state or territory taxation of goods. So in this approach, and I think in Vanderstock in particular, both the majority and the minority judges are taking what I would see as being a very theorised approach to judicial reasoning. They're looking at the underlying policies and all of those things in a very transparent way that I think is less apparent in earlier decisions of the High Court. The minority took a very different approach. Justice Gordon emphasised that a duty of excise is in essence a trading tax. That is a tax in relation to commercial dealings in commodities. Justice Edelman discerned from the authorities three constraints contained in the essential meaning or application of an excise. And these are the ones that traditionally represented what was known as the Section 90 law before Vanderstock. The first was to be an excise, a tax must be reasonably anticipated at the time the legislation was enacted to have a real and substantial economic effect in a market for the sale of goods as articles or subjects of commerce. Second, it was a requirement that the economic effect as a matter of substance be an effect or an equivalent to an effect on the supply side of the market. And His Honour explained this could be described as an economic effect that, independent of demand, changes the price at which supply will be made. And thirdly, the economic effect on the side supply of the market must also be a direct effect in that market rather than an effect that arises indirectly as a consequence of an economic effect in a different market. Justice Edelman recognised that there would always be hard cases on the margins, but those hard cut cases could not justify ignoring constraints any more than the existence of twilight could justify ignoring or abolishing the difference between night and day. So again, very strong language. Justice Edelman was critical of the majority approach, including on the basis that the majority approach removed those second and third constraints. His Honour stated, with genuine and great respect to my colleagues as authors of the engaging, innovative and detailed reasons that combine to form a majority decision for today, but with considerable regret, it is necessary to say that in this single case, the constitutional federalism reflected in the three constraints has been substantially impaired. The first constraint is effectively ignored and the latter two are effectively abolished. The essential meaning of an excise is said now to be an elegantly simple tax on goods, with the only constraint being that there must be some metaphorical impact of the tax directly or indirectly on goods through the liberal and generous application of a preposition. So he's quite critical of the majority approach. I don't know what to make of this language. I mean, I was certainly, when I was a junior, I was told by a silk who I won't name, but one of the leading silks, because I don't want to misquote him, that if you disagreed with a judge, you would say with respect. If you disagreed with a judge who you considered not to be the brightest judge, you would say with all due respect. If President Lucas is smiling at me that this is His Honour excluded, of course. If you disagree with the judge and the judge is plainly wrong, you say with the greatest of respect. And if you disagree with a judge who's plainly wrong and not the brightest judge, then you say with the greatest and utmost and all due respect. So I don't know what to make of this with genuine and great respect to my colleagues, but it's an interesting way because he then goes on, and this is the, it is a scathing attack on the neglect of precedent. And then have this passage, which I think everyone has seen because it was trending everywhere. But I don't think this is, whilst there's some weight to be accorded to all of that, in some ways, I don't think it's the most persuasive reasoning in his Honour's judgment. If constitutional law is to be dynamic, there may well be a movement away from an approach undertaken in previous cases. And that movement might not be like the incremental movement of the common law. I think it all depends on the perspective that you take of the operation of the doctrine of precedent. And I'm very grateful to Stephen McDonald, who drew to my attention. Edelman has just Edelman recently presented a paper, I think last week or the week before, about the overturning of our Catevan report and the questions about the rules of precedent. So my own view is that there's a real question to what extent that sort of what role precedent has when you're dealing with a final appellate court, and whether the constraints that Justice Edelman talks about in the John factors in the paper, the manner in which you apply them can be so different that I think the doctrine of precedent, when you come to a final appellate court, just simply operates differently. I think there's also a real question as to what extent it's necessary in judicial writing to critique different and divergent approaches. I mean, traditionally in Australian constitutional writing, I don't think we have such overt criticism of competing views. It's much less common in Australian legal writing than it is, say, in the Supreme Court in the US, I think. But that's certainly the sort of language that you get in these judgments. So if I turn to, there was also, I'm told, in the judgment, another graphs, which is another innovative approach. I'm not sure. Mike Waite was one counsel in the case. I've spoken to another counsel. If anyone knows where the graphs came from or what they mean, no source of these graphs is cited, and the suggestion that I had heard is that I'm not sure that they appeared in the submissions, but might be able to help us with that. But where does this all lead in terms of judicial method? I think an interesting aspect of judicial reasoning in these three decisions and in the approach of Justice Edelman is that Justice Edelman engages in what I would say is a highly theorised approach to judicial reasoning, whilst at the same time demonstrating a strong adherence to the doctrine of precedent. These aren't, of course, mutually exclusive concepts, but for the reasons that I want to explain, they're often not found in combination. Often a strong emphasis on precedent and the common law is associated with an incremental approach or a legalistic approach to a judicial method. And I think that's one aspect of the decisions I find interesting. Another is the particular regard Justice Edelman has in his judgments to the position of the individual appearing before the court, which I find interesting. To develop this analysis further in the paper, I talk about the distinction between legalism and realism and the difference between top-down and bottom-up reasoning. So the idea of legalism is that there is a set body of ideas, including the rule of law, and that these ideas form an external standard by which judicial decision-making may be assessed and in a consistent way with accepted processes of legal reasoning. This idea that there's a body of defined sphere of legal ideas that represent the shared professional outlook. And so Owen Dixon's jurisprudence and the idea that there's an external standard of legal thought by which decisions can be judged is an exemplification of that sort of approach. In contrast to legalism, the ideas that law is a self-contained knowledge of knowledge. You have the realist movement, which often saw prevalent, these are the words of Justice Oliver Wendell Holmes, prevalent moral and political theories, intuitions of public policies, avowed or unconscious, or even prejudices with which judges share with their fellow men, having a great more deal to do with, in effect, the outcome of legal reasoning than this idea of a very principled approach. One of the benefits often associated with legal reasoning from a particular theoretical standpoint and acknowledging the influence of those theories is said to provide a guide to judicial decision making. So realism often saw and acknowledged presenting legal ideas at a higher level of abstraction. The criticisms of that approach that's been advanced is that when you state principles at too high a level of abstraction, I think Wade might think that about Vanderstock, they may bind courts in future matters in ways that can't be foreseen. So what I think is interesting is the way in which these ideas are presented in Justice Edelman's judgments. His Honour places a strong emphasis upon the common law position and precedents, and that can be seen, for example, when he was dealing with the privilege against, His Honour was dealing with the privilege against self-incrimination. And I think the decision in She, of the decisions I've talked about in the paper, I think was the most persuasive. In relation to the decision of Pattinson, I think it's interesting in that case that His Honour commenced the decision with like such a scathing criticism on parents, but then was also slightly critical of the full court for not applying that, despite his criticisms of that approach based on value of precedent. So that's an interesting combination. And that real regard for precedent, I think, can be seen in Vanderstock and, you know, the passage that is called trending on social media. So I think, in conclusion, I think all of the decisions, but particularly Vanderstock, there's an increased transparency in looking at competing policy considerations in the judgments compared to going back in time in Australia's constitutional jurisprudence, and I think that's really interesting. I think increased transparency in the relative assessment of competing legislative grounds isn't limited to Justice Edelman's judgments. It's found in many of the decisions, particularly in constitutional decisions. I think there is, however, this really strong emphasis on precedent. And the third and final point that I wanted to make, which I think I've developed since my earlier presentation of this paper, is this idea when it comes to judicial writing. And judicial writing I see as being quite different to the form of writing, legal writing found in legal submissions, in the sense that as an advocate, I think we can be quite strong in presenting our client's case, as well as quite openly critical of the other side. The question is, to what extent is that best reflected in judicial writing, and how? Because what we're seeing in these decisions is a much more overt attack on competing viewpoints. Now, I think my own view is that judicial legal writing is most persuasive when it addresses the competing views, but when the principles that have been expounded by the decision are not overshadowed by a critique of alternative perspectives. And the reason I say that is because the authoritative value of judicial authority and judicial independence, and one of the reasons for our separation of powers is important, is the maintenance of judicial authority, the maintenance of judicial authority, is this idea that the losing party will accept the decision. If there's no regard had to the arguments presented by a losing party in a judicial decision, then that's hard for the losing party to accept. If there's a scathing criticism of the losing party's perspective, well, then that's also hard to accept, because the losing party can often see it as being a judgment that's influenced by preconceived views. So that moderated approach of looking at both, but where the presentation of principle and the reason for decision is not overshadowed by a critique of the other side, I think, is the most persuasive form of writing. But that was my decisions. I should say I don't know Justice Edelman at all. I just made this up based on reading these decisions. I do talk about judicial authority more in my book, which has made a recent resurgence on social media under the, it made it to Instagram with Harry Potter because of it being such an awful title. But I have brought a couple of copies. Stephen's already nabbed one. If anyone wants a couple of copies of my book, I have brought some to give away because it's been related. But if anyone has any questions, I don't know how we're going for time, Stephen. I have left some time.
Some time. Thank you so much, Dr. Gray. Is there anyone in the room who has any questions?
You spoke about the sort of open criticism and the potential for it to sort of impact on the losing party's acceptance of the decision. Do you think that there's also scope for it to more broadly impact on sort of confidence in the judicial system more generally?
Well, I mean, I think that's the whole idea about judicial authority is why do we accept judicial authority? What is it about judicial decision making that maintains its authority? And I think one of the things is this idea that the losing party will accept the decision. And I think one of the reasons that people do accept the decision is if they feel ahead of their hearing. And I think the importance of, I mean, I'm a strong believer in the importance of procedural fairness and the idea that you never mind if your arguments get rejected. It happens to me all the time. Happens to me all the time. But when you feel you're not even being heard, I think that becomes problematic. And I think when decisions become, and look, it's difficult because you're talking about the High Court. So of course everything's, I mean, but I almost think when you get to the High Court, almost everything's going to be finely balanced and go one way or the other. Otherwise, why would you be there? Certainly in commercial decisions, but in the states go there anyway. But I mean, most of those decisions are quite finely balanced. But I think it does have that broader impact if it's seen just as political rather than, you know, nuanced. But I'm not suggesting that about any of these cases because these cases are really well thought through. I think, I mean, there's a lot of reasoning in all of them. It's just that it's different. But there is a difference in the style of legal writing, I think, in these particular documents that I've looked at.
You've said that's a sort of a US. Sorry, I'll just jump in.
Yeah, it's all right. It's only President Linda's here. He had his hand up, Stephen. It's fine. Go.
Sorry. Just on that topic, you've sort of said that this was a US style, sort of the judgments almost interacting with each other, or one of the judgments addressing pretty directly what's been said by other judges.
I don't think it's quite US style because I think it's much more well thought out and reasoned. I'm not going to slam the US people, but that approach of engaging with each other, yes, I do agree with you.
I just wonder whether you think that's a sort of a trend that in recent judgments of the court, or have we picked out judgments here that had people's emotions running higher than normal, or is it particular personalities? Do you have a theory as to whether that's a trend, and if so, why?
I think it's too early to say, but it's definitely a difference compared to, I mean, we talk about, well, I have talked about different eras of the High Court, so the Dixon era, the Mason era, the Gleeson era. They were all much more, I mean, you didn't see that approach. Has it changed now? You know, like, I'm not sure because I think you wrote that interesting article on the judgment where you had all of the judges agreeing that there was a separate section dealing with
NZYQ. Yeah.
NZYQ. It was again Justice Edelman who had a different approach. So there was one majority judgment, but within that majority judgment, they expressed different views. So I think we're in a state of transition, is what I would say, and I'm not sure exactly where it's going to go. I mean, I suspect it'll be. I don't think it'll go back to what was like in either the Dixon, Mason or Gleeson eras, because I think this idea that all of these judges are, you know, looking much more at these policy considerations underlying legislation in a much more transparent way. I don't think that's going to go backwards. I'm not sure where it will go on the interaction between minority and majority judgments, whether that will be a feature or whether it's just particular to these cases or particular to Justice Edelman, because we haven't seen it as much in the other decisions as well. So it's not like they're being any criticism that.
My question was about an aspect of what Stephen's already asked you about. It's this. It's one thing for the judges to comment on each other's judgments, particularly if they are critical of each other, whether they're in majority or dissent, doesn't much matter. But what do you think of the trend towards being critical in a fairly catchy or blatant way, in a way similar to the way Justice Scalia was in the US Supreme Court? What I've got in mind is references made by Justice Edelman in Vanderstock to I think he called it forensic respect that he gave to the other judgments. I think that's a dangerous move.
This time.
Not just that, that's obviously fairly showy paragraph, but what I meant is the way in which he was clearly critical in a fairly punchy way about the respect he was giving to the majority judgments. He referred to, I think, was unfeigned forensic respect. Unfeigned and not merely forensic respect was the phrase.
I didn't know what to make of it. Like, I mean, I actually didn't know what to make of it. I mean, I'm sort of curious as to what other people thought, because I was like, is that genuine? Is that, I mean, he said with genuine, I think he said with genuine.
I think if he says it a few times, then you start to wonder.
It was a sort of cascading series that started off with great respect and ending up with genuine and not merely forensic respect. And I think it went through about 6 different versions before it got to that point.
Yeah, I mean, I don't know what to make of it. I mean, and I'm sort of influenced by what I was taught about, you know, the more you say that, the less you actually genuinely mean it.
My question is really directed to, let's assume that it's been critical. Let's just make that assumption for the sake of the exercise. Do you think there's any danger with judges doing that?
Yeah, I think it can diminish overall confidence in the judiciary. I mean, that's the entire, you know, the new bit that I added into this paper that I sort of had developed since I last gave it, is this idea that what is it that maintains the authority of judicial decision? And I think one of the things that does maintain the authority of judicial decision is the way in which judges treat parties to maintain confidence of the parties in the process, because at the end of the day, it is the parties that are the most important people in the courtroom. But the way the judges treat each other, I think, also has the ability to diminish overall confidence in the judiciary. So whatever you think, I mean, I've always thought whatever you think of a judge, if you're appearing before them, they're representing the authority. So there should be some level of respect. That's why we have, I mean, we live in an authoritative system. I mean, a civil society is maintained, I think, and one of the great benefits of our legal system is our separation of powers. For that separation of powers to function well, you need to have confidence in the judiciary, and I don't think confidence in the judiciary as an institution is enhanced by judges being that scathing of each other. You can leave that for the parliamentarians, is my view of it. But that's obviously a very traditional view of judicial authority and our legal system, and the US has a different approach, but they have elected judges there, so it's quite different.
Thank you very much again, Dr. Gray. I might say I would tend to read Justice Edelman a little bit more kindly, and perhaps that he was almost searching for a way of expressing respect that went beyond merely saying, you know, the normal formula that can sometimes be misinterpreted, and it perhaps almost sounds like going over the top, but he might have been sort of trying to find some language that would express genuine respect, and it's obviously being misinterpreted.
I'm
Yeah,
not-
I'm not saying you want to
No,
interpret it.
I just don't know how
Yeah.
to interpret it. Like I actually,
And I'm not confident that I'm right either, but
Yeah.
that's, you know, I'd be benevolent in my.
let's go with the benevolent approach.
But thank you again, Dr. Gray, for that really interesting discussion. Thank you everyone for your attendance, both in person and online. Can you join with me one more time in thanking Dr. Gray? And for those who've joined us in person, we have some drinks and nibbles available here, so please feel free to stick around. And there are 2 copies of the book for you. Thanks very much. Yes.